Hi, everybody. This is Steve Maggi from SMA Law Firm, and today I'm going to talk to you about the national interest exception as it applies to L1B visa holders or visa applicants. As many of you know, there was a presidential proclamation put in place on June 22nd that said that L1s would not be issued for the rest of the year, and that affected thousands of applicants as well as individuals who had their L1 status extended but then were then outside the United States after March 12th. And so this proclamation made it look like there would be no options until the end of the year. What happened was on August 12th, there was something that was amended to include exceptions for specific visas that were not supposed to be issued, including L1 visas. And so L1B refers to people with specialized knowledge, and that means unique and proprietary knowledge that is unique to that specific company, its modalities, its technologies, its protocols, and its way of working that are not clearly or easily accessible by US workers or any other workers. L1B visa applicants have specific knowledge. They have certifications that are created and generated by those companies that they work for, and their experience cannot be replaced by any other worker, which makes them special. And so, luckily for all of you who are either in L1 status, L1B status, and are outside the US waiting for new visas, or those of you who have approved petitions under L1B category who are outside the US can now apply for a national interest exception. It's important to point out that one of the criteria that's specifically mentioned is that people who are already working for the company and have the same position with the same employer and visa classification should be eligible, because forcing employers to replace those employees in that specific situation would cause undue financial hardship to the employer. The economic-based argument here is the most important way to present these cases, on top of the highly specialized nature of the specific individuals and what they bring to the table. So one of the other requirements to qualify for the national interest exception is that the proposed duties and specialized knowledge indicate that they will provide significant and unique contributions to the petitioning company, that the specialized knowledge is specifically related to a critical infrastructure, and that need is really economic, and then that the applicant has spent multiple years with the company overseas, including a substantial knowledge and expertise in the organization that cannot be replicated by a new employee. So the good news here is that the language that's used for the national interest exception for L1B is essentially mirroring the language that is used to qualify under L1B status. And so if you're currently out of the country with an approved petition, I suggest that you apply for the national interest exception. There is no harm done if you are not approved. That does not affect the issuance of your visa in the future, but it could allow you to receive a visa before the end of 2020. For many of you who are going for a 2-year visa or a 1-year visa even, the amount of time that you've already lost is substantial. We have clients who were approved by USCIS in January, could not get a consular appointment, and only have a few months left on their approved petition. So it depends on the circumstances, but what's important to keep in mind is that if you want to come to the US in 2020 under L1B status, you must apply. Applications are filed directly with the US Embassy or consulate where someone resides, and you get one chance to apply. You need to submit a comprehensive submission that includes all the documents, the employer letter, and proof of your certifications and what gives you specifically that specialized knowledge. If you have any questions, we suggest that you talk to a US immigration lawyer specialized in consular law, and we're available anytime to help. Thank you very much for watching.